Welcome to Emphasis Added, a podcast by the Houston Law Review about legal issues, prominent lawyers, and the study and practice of law. I'm Matt Shelf.
And I'm Brock Jones. We're your hosts, and thanks for joining us. We're joined here today by University of Houston Law Center professor Robert Ragazzo to discuss the recent acquisition of Twitter by Tesla and SpaceX's Elon Musk, and what that deal can teach us about acquisitions in general, including their potential pitfalls.
Professor Ragazzo is an expert on securities regulation, as well as business organizations and closely held corporations. Before his illustrious teaching career, he attended Harvard Law, clerked for the Honorable John O. Newman of the United States Court of Appeals for the Second Circuit, and practiced law at Wachtell, Lipton, Rosen, and Katz. He has co-authored a casebook on business organizations and is currently working on a treatise about the law of closely held corporations. Professor, thank you so much for joining us today.
Well, it's a pleasure to be here, and obviously Musk's acquisition of Twitter poses a lot of interesting questions.
We're really excited to talk about it. So, Professor, just before Musk's court-ordered deadline at the end of October, he closed his acquisition of Twitter for $44 billion. In doing so, he avoided a lawsuit that many believed would force him to complete the purchase after he threatened to not follow through with it. What are the major steps involved in a legal acquisition?
Well, there's any number of steps, but this was an easy one. He basically had an agreed-upon deal with Twitter to acquire the company in what we would call a reverse triangular merger. That is, he created a sub that was to be merged into Twitter, with Twitter being the surviving company. That would require a vote of the Twitter board of directors and the Twitter shareholders, but given that it turned out to be a beneficial deal for Twitter, they certainly would have all voted for that, and then he gets to close the deal.
Good deal. Good deal. What are the ways in which a company can be acquired outside of that context?
You could buy all the assets. You could do a hostile acquisition to make a tender offer for the company if the board decided to oppose you. But here that wasn't necessary because the board ultimately accepted his deal.
And so I guess the way he did this, everybody thought was the most reasonable way, but why go through the reverse triangular merger process as opposed to any of the other options?
Because unlike a tender offer, it allows them to acquire 100% of the stock. That is, anybody who votes against the merger would have the right to an appraisal, but he would get to buy all the stock in one shot. He wouldn't have to acquire, say, 91% of the stock by buying it directly from the shareholders and then have to come up with a way to squeeze out the other 9%. Now, he could do that and that would work, but it would take longer and be more complicated. So because he had a deal with the Twitter board, this is much easier because now everybody has to sell to him at $54.20 a share. And once he completes it, that's it. He owns 100% of Twitter.
Sure. In March of 2022, Musk purchased his initial stake of Twitter, was a little bit over a 5% interest. Shortly thereafter, he increased that interest to a total of about 9%. When he finally disclosed that he had purchased these shares, the price of Twitter shares soared. What are, if any, the disclosure requirements for purchasing significant stakes like that in a public company?
But here there's a lot going on. That is, once you buy more than 5% of a public company, you have 10 days to file either a Schedule 13D or a Schedule 13G declaring your ownership stake basically to the world. And so he started buying stock whenever he started buying stock, and then by March 14th, 2022, he had acquired more than 5%. That means he had until March 24th to file one of these schedules, which I gather he didn't do until April the 4th, so he was 10 days late.
Sure.
And that creates a lot of problems. He's clearly violated Section 13D of the Securities Exchange Act. And it's a little hard to tell how much money he saved himself by doing that. I've seen a lot of press reports that say, he ultimately bought about 9.2%. And the threshold in Section 13D is 5%. So he sort of has violated Section 13D with respect to that extra 4.2%. That isn't obviously right, because after he bought more than 5% on March 14th, he had 10 days to buy as many more shares as he wanted. Okay. The only violation of Section 13D has to do with shares that he bought after March 24th and before he filed on April 4th. Now, I've seen other press reports that say that he had acquired a 7.5% stake by March 24th. I have no idea if that's true, but I've seen press reports that say it. If that's true, what he gained by violating Section 13D wasn't the entire 4.2% that he bought more cheaply. It was the 1.7% he bought between March 24th and April 4th. And if you want to think about how much he saved, the stock was trading at around $39 before he made his disclosures. It went up to about $50 on the day he made his disclosure on April 4th. So he saved about $11 a share by not making the disclosures that Section 13D required. And if you take $11 a share times the number of shares he bought between March 24th and April 4th, then you'll know how much money he made by violating the law. What's really interesting here is that the SEC didn't sue him.
Right.
Because it's the SEC's job to police Section 13D. And let me just say, the SEC has not been very aggressive in policing Section 13D violations, and you can see that here. They sent him a letter in May saying they were investigating whether he violated Section 13D. I'm not sure what there was to investigate. He was clearly 10 days late by his own admission. And, why the SEC didn't sue him right away is a very interesting question.
So if the SEC isn't going to take action on this, and that, like you said, that figure seems to be $11 a share for however many shares, somewhere between 2% and 4.2% of this giant company, is there a private cause of action for shareholders who made a purchase of Twitter stock between March 24th and April 4th when the price should have been 50, but I guess they're getting a good deal.
Well, but they're not getting as good a deal as they should have gotten, so we'll talk about that in a minute. But why didn't the SEC sue him? That is, the Securities Exchange Act allows them to sue in district court for a civil penalty, which the judge has the discretion to set at a maximum at the amount of money that must gained by violating the law. So a district judge would have had the authority to issue a fine equal to $11 a share times whatever shares he bought between March 24th and April 4th. Now, I've seen press reports saying that's anywhere from 150 million, 163 million. I'm not sure how they're counting. I'm not sure whether they remembered that what he bought between March 14th and March 24th is okay. But however you want to set that up, it's pretty easy to figure out how much money he saved. And then what you might do is you might put that into a pool and say that all the investors who sold stock between March 24th and April 4th can take the money out of that pool in proportion to their trading interests. So, no one can know with whom Elon Musk actually traded because exchanges on the stock exchange are completely impersonal. You have no idea who the other parties are. But that's how we do it in insider trading cases. We say you're responsible to everybody who traded contemporaneously. Your loss is limited to the amount you saved by violating the law, and then all the people who traded contemporaneously, take from the pot in proportion to their trading. We could have done that here. Now, I have to say that, judges are often hesitant to grant very aggressive remedies in Section 13D cases, which may be one of the reasons why the SEC has not been so enthusiastic about pursuing this kind of case. But one wonders why the SEC didn't do this, especially since they've had Elon Musk on their radar for a long time. They sued him for disclosures he made about Tesla. He once tweeted out that he was thinking about taking Tesla private and that he had the financing in place to do that. That turned out to be untrue because he didn't have the financing in place to do it. So the SEC sued him, and there was just a major settlement of that case. Musk has been public in saying that he has ultimate contempt for the Securities and Exchange Commission. Now, normally the government notices that. They never admit that they do anything for that reason. But normally, if you're on their radar because you've said things like that, normally they're paying attention to what you do. So I wonder, what happened here at the SEC. Now, because the SEC didn't sue him, the only alternative is then for private people to sue him. And there is indeed a class action pending in federal district court suing him for, violating the Section 13D rules. What's interesting about that is that action is filed under Section 10B of the Securities Exchange Act, and Rule 10b-5 It's not filed under Section 13D of the Securities Exchange Act, which is the provision he violated. The reason for that is a lot of lower courts think that there is no private right of action under Section 13D for damages. Now that's an interesting question because there's a 1975 United States Supreme Court case where the Supreme Court says in a dictum that, of course, issuers cannot recover money under Section 13D because the section wasn't designed by the Congress to protect issuers. But aggrieved shareholders should be able to sue for damages under Section 13D. Now that was a dictum, to be sure, because aggrieved shareholders weren't bringing that case. But the lower courts have tended to ignore that. Basically, the Supreme Court changed the law on when there would be private rights of action in the 1970s. And pretty much what the Supreme Court was telling you is that it grandfathered in all the private rights of action that previously existed, and it was going to be very difficult to create new private rights of action. And so most of the lower courts have taken the view that there is no private right of action under Section 13D. Now, a lot of those cases don't involve trading shareholders as the plaintiffs, so I'm not sure how directly applicable there are. There are a few cases that do involve trading shareholders where the courts say there's no private right of action. But that's sort of an interesting question. I'm not sure that's been settled. But because the trend of the law is the other way, the plaintiffs in this class action chose to sue under Section 10. Now that creates kind of its own problems because Section 10 only punishes if you lie in connection with the purchase or sale of a security. What's an interesting question, how Elon Musk lied when he failed to file a schedule that was required by Section 13D of the Securities Exchange Act. A lie can be one of three things. It can be an affirmative misrepresentation, which of course he didn't do because by not filing he didn't say anything. It can be a half-truth, which of course he didn't do because he didn't make any affirmative misrepresentations or any affirmative representations of any kind. And you can lie under Section 10 if you are silent when you have a duty to make disclosure. Now, most of the 10b-5 cases involve a duty to make the disclosure that flows from state law, particularly the state law fiduciary duties. Whether that duty to make disclosure that gives rise to an obligation to disclose all material facts can flow from the disclosure obligations of the federal securities laws is kind of an interesting question. Now, there are some cases that say the duty to make disclosure can flow from the disclosure obligations of the federal securities laws, but that's hardly clear. And so they've chosen to pursue their case under 10b-5, and that's in a way kind of a stretch. Also, you might fairly ask, if there's no private right of action under Section 13D, why does the private right of action which the court implies under Section 10 and 10b-5 sort of allow you to bootstrap a 13D claim that otherwise didn't exist? And so that's going to be an interesting case. It's not so clear that the investors are going to have standing to sue for damages basically under Section 13D for failing to file his schedules on time. Now, if they win, I would think they would get $11 a share times the number of shares he bought between March 24th and April 4th, and then they would split that up among themselves in proportion to their trading. But that's going to be an interesting question. It's not so clear that individual investors can enforce that obligation.
Absolutely. Would that kind of bootstrapping question apply to more sections than just 13D? Is that question, can you create kind of down a back road a private right of action under Section 10b-5 for any other disclosure obligation that didn't previously have its own cause?
Well, that's a problem because since 10b-5 is an implied right of action, what the court is telling you is that basically Congress intended there to be a private right of action, even though Congress really didn't address the question one way or the other. Since they didn't address the question one way or the other, that's a funny kind of congressional intent. And now we're kind of going to the next level and asking, what did Congress intend the elements to be for a claim that they never really thought about in the first place anyway?
Right.
And so now you have to ask, well, did they intend you to allow you to use Section 10 to sort of do an end run around the fact that Section 13 can only be enforced by the Attorney General in a criminal case in the SEC for civil penalties? And who knows, because we're asking, now a sort of a second-tier question of what the Congress intended as to something they probably didn't think much about. In fact, something I'm sure they didn't think much about when they passed Section 10. So who knows?
Interesting.
Very interesting. So, Professor, when Musk finally disclosed his interest in Twitter, he implied that he would be a passive investor with no plans to seek a board seat and no plans to make significant changes in the company. So aside from potential financial gains, why do investors purchase substantial stakes in a company planning to be passive?
Well, let's talk about what Section 13D is about and why nobody cares. The point of Section 13D is to prevent creeping acquisitions. That is, when you offer to buy control of a company, you usually pay a substantial premium. Indeed, Musk's 54.20 offer is about a 38% premium to the price the stock was trading for before he made his announcement. And that's within the range of what acquirers normally offer as a premium. If you were able to buy your stock without telling anybody that you had bought a large accumulation and were intending to acquire control, you could avoid paying that premium. And indeed, no doubt, Musk benefited substantially by not filing his 13D on time. And so that's why anybody cares sort of about Section 13D. Now, remind me what your question was.
So aside from potential financial gains, why would someone seek to be a passive investor?
Oh, I'm sorry. Anybody can seek to be a passive investor. That is, you might invest in Twitter just because you think it's a good business. Warren Buffett does this all the time. He invests in businesses he believes in. He has no intention of controlling them in any way. And so that happens all the time. Now, if you are a passive investor, you have no intention to seek control or to influence control of the company, then you get to file a Schedule 13G instead of a Schedule 13D, which is similar but a little easier to file. There are fewer disclosures required. By filing a Section 13G, Elon Musk basically told the world he intended to be a passive investor, somebody who had no interest in either seeking control of the company or influencing control of the company. Now, that's an interesting choice. The mere fact that prior to his disclosures on April 4th, that he had suggested changes in Twitter's business model does not mean he was lying about being a passive investor. The SEC has been reasonably clear that just seeking to change the business policies of the company does not make you a person who's interested in influencing control, and you can file a Section 13G. But on the same day that he filed his Section 13G statement, or Schedule 13G statement, Twitter announced that they had a deal with him to make him a board member. And they also filed that on April 4th. They filed a Form 8K, a current event report that they're required to file under the Securities Exchange Act. And it's clear from tweets that Twitter's CEO made the following day that those negotiations had been going on for a while. So it's an interesting question whether, Musk really was a passive investor on the day he filed his Schedule 13G. Now, you can sue him for that too. You can sue him for fraud. You can say he lied when he filed his Schedule 13G. And this time, it's pretty clear you do have a 10b-5 action. Because if he lied, that was certainly in connection with the sale of Twitter stock. And so that's something you could sue him for. To the best of my knowledge, that hasn't happened yet. That is, the class action currently pending is about his failure to file a Schedule 13D, not that he lied when he originally filed. And I guess that's because that's a very difficult action to win. It's easy now to look at this and say, well, he got a board seat, or he's offered a board seat, which he turned down, but he was offered it. He negotiated for it. Then, within a month, he had a deal to buy the entire company at $54.20 a share. That means he must have known he was not a passive investor. So he was lying. And if he was lying, he was depressing the stock price, because had he disclosed he had a control intention, the stock price would have gone up more than to $50 a share on the day he made his disclosure. And so people who sold into a depressed market that they shouldn't have had to sell into. Problem is, you have to prove he was lying on the day he made the statements. He's going to say, when I filed the Schedule 13G, at that moment I was intending to be a passive investor. As soon as I knew I was being offered a board seat, then I amended my disclosures. I changed my filing to Schedule 13D. And then when I made my offer to buy the company, then I amended my Schedule 13D to say I was seeking to buy control of the whole company. If you're going to beat him in that kind of fraud action, you have to prove he was lying on the day he made the statements. Mm-hmm. Now, you can ask the jury to infer that what he did afterward shows that on the day he made the statements he was lying. But that's not so easy to prove. So that also exposes him to potential litigation, but it'll be interesting to see whether he gets sued for that.
Definitely. So when Musk first approached Twitter with plans for his acquisition, the board was not interested in his offer to take the company private at all. However, they did not reject the offer outright. So why didn't Twitter's board reject this offer?
Well, they didn't reject the offer initially because it was at a 38% premium, which is not a bad premium. That's not high by the standards of takeover premiums, but it's not terrible. And so the Twitter board actually acted pretty well here. That is, usually when there's somebody like Musk that they don't like, who wants to change their way of doing business, they usually defend, in every way that they can. And state law allows them to defend to a large extent and lets them generally turn down offers that they don't want to accept. And so usually they hire an investment banker to say that the offer is inadequate, even though it offers a substantial premium. They say they're defending against the offer to protect their employees from being fired, which, by the way, the Delaware courts say is a legitimate reason for opposing a takeover prior to the time you decide to sell the company. When you're still defending the company, that's a legitimate basis of defense. And so normally they fight tooth and nail against this kind of acquirer. What the Twitter board here did was actually pretty impressive. That is, as you say, first they offered him a board seat. They didn't reject the offer out of hand. They were willing to talk to him about it. And then eventually, by the end of April, they'd accepted it. And by the end of April, of course, because the stock market had been falling, the offer began to look better and better over time, and then they finally accepted it. Now, let's remember what that meant. He fired all the senior executives, which he always intended to do, which, of course, the board knew he intended to do. And usually people fight against that kind of displacement, but they didn't do that here. And so they really cared about their fiduciary duty to their shareholders, and they ultimately accepted a deal that looks like it's going to be very beneficial to Twitter's shareholders. So we shouldn't miss the fact that, the Twitter board acted pretty well here.
Absolutely.
Absolutely.
Are there any other considerations beyond their fiduciary duties to their shareholders that the board has to consider?
Well, they don't have to consider anything else.
Okay.
But the law generally allows them to consider non-shareholder constituencies, like their employees, like their customers and suppliers, like their ties to the community. A lot of academics think that that's wrong because they should care only about shareholder value. But Delaware law is pretty well settled, and the law in most of the rest of the country goes at least as far as Delaware in saying that you can consider non-shareholder constituencies. Indeed, Delaware says that once you decide to sell the company, you can only consider the value to shareholders. Over 40 states have passed statutes saying that you can continue to consider non-shareholder constituencies even after you decide to sell the company. So interestingly enough, most of the states have gone even further than Delaware in protecting non-shareholder constituencies. Interestingly, Texas is one of the few states that has not passed that kind of statute. But in general, that's entirely proper.
Very interesting.
And so even if they get, what could be to the market an objectively good offer, is it just the business judgment rule that they can say, we think we'll get a better one from somebody else, or we don't actually think he has the financing?
It is theoretically not the business judgment rule. Theoretically, Delaware has an intermediate standard of review that you have to satisfy to engage in defensive tactics. But the Delaware courts have applied that standard so generously from the perspective of target companies that it's almost the equivalent of the business judgment rule, regardless of what they say. And because of that, it's probably true that Twitter could have defended against this offer. Now, all the cases in which the Delaware courts have said that you can consider non-shareholder constituencies also involve claims that the offers being made were inadequate. So it's a little hard to tell what the Delaware courts think is the independent significance of considering non-shareholder constituencies. And, you may consider them, but how much value can you give up? Can you give up $2 a share to help the employees? Can you give up $100 a share to to
Sure.
help the employees. I've always thought that the right answer to that is probably similar to what we think about charitable giving in general. Generally, corporations have the power to give money to charity, but we normally think that that has to be reasonable in amount. You can't give up 50% of the company's assets to charity. I would have thought that the rule here would be reasonably similar, that you can consider non-shareholder constituencies, but you can't have too large an impact on shareholder value. But it's hard to know because we've never had a case where the board ever said, hey, that offer is okay, and we're only costing the shareholders $2 a share to help employees, and we ought to be allowed to do that. I mean, that's never come up. They've always defended on both grounds, and the courts have sustained them on both grounds. And so it's hard to know how much they could have considered employees at the expense of shareholders, but the law's at least clear they were allowed to consider it.
Sure. Now, you said obviously as the deal started to look better and better, the Twitter board went along with it more and more. But initially, when they were trying to stave off, they used what is called a poison pill.
Yeah.
So can you tell us a little bit about what a poison pill is and how it worked in this case?
Sure. They adopted what we would call a flip-in poison pill with a 15% trigger. That is, they issued rights to all their existing shareholders that gave them one right per share. And that right would kick in if somebody bought more than 15% of the stock. And if somebody bought more than 15% of the stock, each of those shareholders would have the right to buy a specified percentage of shares for half price. Usually you get to buy $200 worth of the company's stock for $100. And everybody has that right except the 15% shareholder. And so what that means is if you cross that 15% threshold, you then subject yourself to enormous economic dilution, which is why, to the best of my knowledge, nobody's ever tried to buy through a flip-in poison pill, which is triggered merely by crossing that threshold. There are also what are known as flip-over poison pills, where if somebody who buys over a particular threshold and then tries to combine its own operations with the target company in some way, that triggers the right to buy at half price. But in a flip-in pill, it's merely crossing the threshold that gives people the right to buy at half price. And, that's kind of a tough economic pill to swallow. Now, the rights can be redeemed by the board for a nominal price if the board gets a deal that it likes. So the real point of the poison pill is to say that you can't buy the company without the board's consent.
Got it.
In fact, really, that's all it does.
Sure.
So when they originally adopted the pill, it was part of their deal to offer Musk a board seat. What they were saying is, you can have a board seat, but you can't buy more than 15% of the stock. So you're not going to get to use your board seat as a springboard to gaining control. Now, as time went by, and Musk's offer began to look better and better, and it looks better today than it did in April when the board accepted it, because the market has continued to decline, except for yesterday. What the board did was they determined they would redeem the poison pill to allow his offer to proceed. So now it wouldn't stop him from buying more than 15% of the company. But that's the basic point of a poison pill. That's entirely legal to adopt one under Delaware law. And Delaware law has been pretty generous in allowing target companies to use poison pills to prevent offers that they don't approve of.
Sure. Yeah. And my co-host here tells me that poison pills came into popularity potentially through your firm in the 80s. Do you have any asides about that?
To be fair, Marty Lipton, our senior partner, is sort of one of the people who invented it. And our firm defended the legality of the poison pill in the household case in the Delaware Supreme Court, which was the landmark case approving the ability of boards to adopt the poison pill. So I think it's fair to say that Wachtell Lipton had a very major role in both designing the poison pill and then in defending it in court.
Well, that's very cool, and we're thrilled to have you here
is.
as the one to talk about it. So
Definitely.
that's awesome. I want to flip and talk a little bit about the financing of the deal. So
Sure.
by most accounts, Musk is the world's richest man. things change every day. I don't know. Today's episode filmed Friday, November 11th. Before his purchase of Twitter, his net worth was roughly $250 billion with a B dollars. He's grown many companies to astronomical valuations, Tesla, SpaceX included, making investors billions in the process. But all of that said, many investment funds and large banks held out from joining the financing on this Twitter acquisition. And a lot of those that did provide financing, it joined at kind of a lesser rate than they normally would have. So with his track record of success, why was there such hesitancy in the banking community to join this deal?
I think it's because he didn't have an economic reason for buying Twitter. Surely he thinks he can improve Twitter's business profile. And I have no doubt that he intends to do that because he spent $44 billion to do it. But usually when an acquirer pays a substantial premium to buy a target, they have a preconceived plan for how they're going to improve the value of the target company. So for example, if the target is a conglomerate, the market thinks that conglomerates are inefficient. You can usually sell the assets for more than the combined value of the company, and you can make a substantial profit doing that. And so you kind of have a business plan to improve the efficiency of the target when you go in. If you think the company's badly managed, you might have management ideas that are different from the current company. If we manage the company my way, it's going to be much more valuable than it is. And that's why I'm paying a 38% premium to buy the company, because the company is going to be more valuable in my hands than it is in the hands of the current management. But that really isn't why Musk bought Twitter. He bought Twitter for social reasons. He thinks that they're unfairly abridging freedom of speech, they're unfair to conservatives, they're unfair to the former president, things like that. And you can kind of see that in the way he's bumbling along. That is, he announced this week that people should anticipate that Twitter will do a lot of stupid things that they're going to have to take back. And that's going to be okay because they're going to kind of learn as they go. Now, that's not normally your business plan when you put up a big premium to buy a target company. One of his initial ideas was going to charge people $8 for being verified on the Twitter platform so you would know their identities were verified. This morning he announced they were jettisoning that idea. So he's clearly making this up as he goes along. He didn't particularly do it for economic reasons. You can see why people were hesitant to join him on this one. If he's designing new rockets for NASA, people are excited about being in on that because he seems to do that better than anybody else. But this time, you kind of wonder, does he really understand the social media industry? And what he said and done since then suggests that it's not so clear. And a lot of the other stuff he said suggests he's not doing it for an economic reason anyway. Now, given how rich he is, he can afford to lose $44 billion on Twitter and still be a very rich man. But not everybody gets to say that. And so, I think I understand why there was some hesitation here.
Absolutely. Now, part of a basic question is, for a man worth this much who could presumably have the cash, why did he need banks involved at all? But in the time span between the acquisition negotiations beginning and the deal closing, like you said, the markets have been in dramatic decline. The financial world has been rocked by rampant inflation, skyrocketing interest rates. And this has just resulted generally in a lot of banks pulling back on their financing activities. So kind of a couple of questions are, how do trends like these impact a deal at closing? And then are there legal implications for a bank pulling out of a deal in light of an economic downturn like the one that we're in?
Well, I'm not sure that, if a bank made a commitment, they might be breaching their contract by pulling out. But why didn't he finance the whole thing himself? Well, he might have, but he had to sell a lot of Tesla stock to finance his portion of the deal because Tesla shares fell 35% from the day he had his deal on the offer until, last week. He had to sell a lot more Tesla stock than he was planning to sell to come up with his portion of the acquisition price. I assume the reason he wanted outside lenders involved is he wanted to restrict the amount of Tesla shares that he was going to have to sell. In the end, banks lent him about $12.7 billion of the $44 billion. But even they have sort of, felt the pain of that a little bit because their lending fees don't look as good in light of the inflation that's occurred, if they were to sell those loans, they would have to take a loss on their next profit and loss statements. Now, most banks would like to sell these loans because banking is a highly regulated industry, and by keeping the loans, it restricts the amount of money they can lend to other people, which of course they would rather lend at higher interest rates now. By keeping the loans, that restricts their ability to do that. On the other hand, if they sold the loans, they're going to have to take a loss that people estimate in the aggregate will be about $500 million. Wow. And so they're not excited about taking a $500 million loss to get these loans off their balance sheet. And that's why a lot of these banks have announced they plan to hold the loans until sometime in 2023. I guess on the one hand, they're hoping to postpone the loss. Then they're hoping that if interest rates go back down somewhere, the loss will be smaller. And in any event, if they sell the loans over time, they can kind of string out when they have to declare their losses. So the banks may not be so excited about having been involved in this, but that's what happens when interest rates go up.
I think I read somewhere this was going to be the biggest kind of hung deal of all time. So major.
A, it involves a lot of money, and B, it involves a lot of losses when they decide to sell the loan. So it's an interesting question if you're a bank.
Got it.
So at one point in the negotiations, Musk declared that he wasn't moving forward with the deal, as we've discussed. However, Twitter reversed course and sued Musk to complete the deal, despite initially doing all they could to stop him. Is there any legal obligation to complete an acquisition once negotiations have begun?
Well, there's no obligation to complete it once negotiations have begun, but these guys had a deal. They had a contract. This is not just they had negotiations. And to be a little fair to the Twitter board, they didn't do everything necessary to stop him. That is, they seem to have had an open mind from the beginning, and they accepted his offer actually pretty quickly. So once they had a deal at the end of April, now he has a problem because he has a contract that requires him to go forward. Mm-hmm. And his contract was a little tighter than most. That is, most of these contracts have conditions that have to be satisfied. And if they're not satisfied, then the acquirer gets to back out. So most of these acquisitions are contingent upon obtaining financing. His wasn't, because he said he had his financing in place by the end of April. A lot of these acquisitions are contingent upon doing due diligence. His wasn't, because I guess he didn't think he needed to do any due diligence. The only real condition in his contract had to do with materially adverse events, which these contracts typically allow for. But because this was a friendly deal, it was a very narrow definition of what a material adverse event would be. And so it kind of restricted his ability to back out because he had a much tighter contract than most of these acquisitions involve.
Didn't he try to claim that the bot accounts on Twitter were an MAE effect?
He did. He tried to claim that their spam or fake accounts were something they hadn't fairly disclosed. But that wasn't one of the conditions on closing.
Exactly.
There was no warranty on spam or fake accounts. Now, he's going to say that basically you lied to me about something material, and that allows me to get out of the deal, but that's a stretch. Mm-hmm. Also, it's not at all clear that Twitter actually lied to him. That is, it's not, whether his basic underlying charge is true is not so clear. I mean, Twitter knew they had fake accounts, and they appear to have, told him something about that. And, it's not clear to me that they were lying. Now, who knows? But, so that's kind of a stretch. So that was tough. He was going to have a tough road to hoe to get out from under this contract.
Was there kind of so I guess if he really wanted out, was there a breakup fee, an amount that he could pay to just wipe his hands of the deal?
Yeah, actually, I'm not sure. I'd have to check that. I'm not sure.
Because I have to wonder, like you said, he's been bumbling along a little bit since the deal closed. And I think he has lost, as far as, net worth goes, hundreds of millions of dollars. And some of the other billions. Some of the other shareholders who stayed on have also seen dramatic declines. So if he had known what the consequences of closing the deal were, why he wouldn't have just paid whatever sum that was.
Well, he might have, but on the other hand, Delaware Chancery Court might easily have granted specific performance to Twitter. The chancellor, Kathleen McCormick, was the same chancellor who decided a case about a year ago that involved Kohlberg and Company making an offer for a company that made birthday cakes. And when the pandemic hit, the acquirer got cold feet because they thought that people would be having fewer birthday parties. And so buying a birthday cake maker was not as attractive a proposal to them. And they had a stronger case because their contract was conditioned on their obtaining financing, which they hadn't obtained, though the contract required them to use their best efforts to obtain financing. Well, the chancellor found they hadn't used their best efforts, so they weren't going to get to use that escape clause, and she granted specific performance. She saw it basically for what it was, an attempt to wiggle out of the deal. And she said, I'm not going to let you do that.
Wow.
And she was going to be the judge in the Chancery Court in the case that was going to be tried the week after Musk gave up and decided to buy the company. So it's not at all clear that he didn't have a very bad draw in that regard in the Chancery Court, and it looks like he was probably going to lose.
Yeah. So when you have a case like this where there's not clearly a breach of a covenant or a representation or a warranty, and the case is going to lie on this materially adverse, are those normally strong, or does the fact that he closed it imply he thought he was going to lose?
That was also a claim in the Kohlberg case, but the problem here is he had relatively few conditions to closing. His conditions were that there was no material adverse event, which was very narrowly defined, that the transaction was approved by shareholders, which has to be true in a merger anyway, and that it got regulatory approval, which of course has to be true anyway. If the government says you can't do the transaction, you can't do the transaction. So there really wasn't much in the way of conditions on closing. And let me just say, the Delaware courts often take a big picture of these cases. If they think you're trying to get away with something, they will find a legal reason why you're not allowed to get away with it. And I suspect his legal team got the sense from dealing with Chancellor McCormick in the earlier stages of this case that she wasn't taking a very broad view of his reasons for canceling the contract.
And that specific performance is a fairly new trend in the Delaware court, right?
I would say that there are Delaware cases that do it, but they're all like the Kohlberg case. They involve much smaller companies. Mm-hmm. Now, should it really matter that it's a $44 billion acquisition instead of a smaller acquisition? That probably shouldn't matter. But the Delaware courts are always hesitant about giving relief they can't enforce. So there was a 2013 case involving a Chinese company where the court decreed specific performance, and the company refused to do it. So they held the company in contempt. They eventually issued arrest warrants for 2 executives of the company should they ever travel to the United States. But that's not something the Delaware Chancery Court wants to be involved in. Now, on the other hand, Elon Musk wouldn't have the same ability to avoid a Chancery Court judgment that this Chinese company had. He does enough other business that he's going to be before the Delaware Chancery Court again. It's not going to be the last time he's there before the American courts. And of course, he has assets to seize, so it's not like he's in China. But having said that, the Chancery Court is often hesitant in granting specific performance, and they might have been more hesitant given the size of the deal. Mm-hmm. So remember that specific performance is always sort of a discretionary decision by the chancellor. It's not something you have a legal right to. And so it's not 100% clear that the chancellor would have decreed specific performance. But if I had to bet on it, that's probably what was going to happen.
Yeah. So now it's closed and done, right? The workforce has been halved. The board has been dismantled. And probably since we drew up this outline and since we started talking 30 minutes ago, there have been new developments, I'm sure. Policies are getting tracked and backtracked pretty rapidly. So since we've touched on a lot of this, where do you think he goes from here?
Well, it's interesting. So he obviously fired a lot of employees. Now, there's nothing wrong with that, and that's typical. Indeed, when you take over a company, especially if you are at odds with the company in some way, and he was at odds with Twitter, even though it was technically a friendly deal because they accepted it, you normally are going to fire all the senior management because the last thing you want is people sticking around who like the way business used to be done.
Sure.
And so that's going to be something you typically do, unless it was a really friendly deal and you sort of supported the current management. Then you might keep them on. But in this kind of deal, you're going to get rid of the senior management because you have no choice. Now, he also fired a huge number of employees, which I think he did for business reasons. And, of course, he's allowed to do that unless they had contracts for a term. Most people are employees at will, so he can fire whomever he wants. That turns out to look like a good decision because just this week, Facebook announced they were laying off 11,000 employees. So it looks like in the social media industry, there was substantial overemployment. Now, it's an interesting question whether Facebook would have done that if Musk hadn't done what he did. Indeed, there is some sort of tendency to keep employees on beyond the term you should keep them on for economic reasons, because after all, the current management is the one who hired all of them. And in fact, a lot of takeovers are done for the purpose of reducing that kind of inefficiency. So I suspect here he was probably right, because Facebook did exactly the same thing. And maybe they did it because they saw the same economic reasons that he did, or maybe they did it because they couldn't deal with the competitive pressure now that he'd done something that made economic sense. But there he actually looks right. It looks like there were too many people employed by these social media companies because Facebook didn't have any takeover. They just did it because they thought they were better off without 11,000 employees. So it looks like he's probably doing okay in that regard. But what he's going to do to resurrect the profitability of Twitter is a much different question. And I'm not sure he has any clue. Because even when he comes out and says, I'm going to do a lot of things that are stupid and have to take them back, you have to bear with me, that's not usually what acquirers have planned to do. And I'm not sure he knows. And I'm not sure he cares. Because he really did this for other reasons. So in a year, he's going to be able to say he's resurrected freedom of speech. He's made the platform fair to conservatives as well as liberals. He's, improved the social media existence. And he's worth enough that if he wants to spend $44 billion on that, he can spend $44 billion on that.
Fair enough, I suppose. Now, not all of the employees laid off look like a great idea because there's been widespread reports of entire teams that maybe could have been integral to, content moderation or safety and security of passwords, etc.
Even
that
the
are
server management.
Yeah, that have been dismantled, and some of them have been called back. How do you see that playing out?
That has to do with his lack of familiarity with Twitter. That, as I assume, when Facebook laid off their 11,000 employees, they knew whom they were laying off. They were careful about the people they kept, and they did it right. On the other hand, Musk has been involved with Twitter for a very short time, and he may have just taken sort of a machete to the problem without thinking more carefully about it. And that's why he's had to hire some of these people back, and might have made a mistake about some of the people who aren't coming back that he wishes he hadn't fired. So he's probably right about needing to fire a lot of people. But whether he did it the right way is a problem, and that's because of his lack of familiarity with the company. And that, of course, is a problem in other areas, too. And that's why he might have something of a business problem going forward. I mean, this is not a car company. It's not a rocket company. This is a social media company. And he has no history in running social media companies. Now, maybe he'll figure it out. Maybe he's a good enough businessman that he'll figure it out. But, who knows? And so this is an example of what the problems are that are caused by his basic lack of familiarity with Twitter and their business.
Yeah, I think I saw yesterday he announced a possibility of bankruptcy. So hopefully he can figure it out before that happens.
Well, look, that's always a possibility too,
exactly,
right?
Exactly.
That, of course, will solve the problem of Twitter abridging freedom of speech if they go bankrupt, but I assume that's not his first choice.
I would imagine that part of the pressure to fire all those folks so quickly, like you said, you buy a company like this because you think you can make it more profitable in some way, and so if you think that there's this vast overemployment, then that's a pretty cut and dry, easy way to make it happen, right? If he needs to do it so quickly so that employees know who's staying and who's going, so that not everybody is there just looking for their jobs, then that's one thing. But I'm not sure if I'm a Twitter employee today, even after kind of the herd has been culled, that I'm not still looking for other employment.
Well, no, that's an interesting point. I mean, you normally want to do these firings quickly because you want to be able to say to everybody who's left, you don't really care how much the people who were fired hate you. What you care about is the motivation of the people who stayed. And so you normally want to be able to say, hey, look, we did the firings we're going to do. Everybody else is going to stay, and so don't worry about it. The trouble here is that because of his adversarial relationship with Twitter, people are still going to feel uncomfortable about this, and nobody's really sure that he's thought carefully about exactly how many people he needed to fire. And so that's something he might have done in a more considerate way. That is, given that, he's going to have to bring people back that he wishes he hadn't fired, tomorrow he might also decide he needs to fire more people that he didn't fire, because it doesn't look like he's thought this through in any organized way yet. And that is sort of a business mistake. That is, what you want to do is you want to think about exactly whom to fire. You want to do it quickly. You sort of want to cut off what you're going to cut off and keep what you're going to keep, and then tell everybody we're moving forward. And he has a hard time presenting it that way. So Facebook, for example, I think is going to have less trouble in that regard, because their management is not viewed as being adversarial to their employees. They probably did consider this carefully, and I suspect that the people who are staying will be highly motivated to continue to help Facebook. Let's see if he's in the same position, but that's part of the problem he has in the way he bought Twitter.
Yeah. And we've said, maybe he can afford to lose the $44 billion on this. He bought the company for social reasons, etc. But I'm kind of thinking he's still connected with Tesla. He's still connected with SpaceX, etc. So, if banks financed $12 billion of this deal and the public is watching his every move right now, he has to be under some pressure to make this a successful operation, or it will affect his relationships with the people he's involved with going forward, would it not?
It no doubt affects his reputation, but on the other hand, the sort of criticism that I've leveled at him, that he has no experience in the social media industry, is really not true with respect to those other companies.
That's fair.
That he's done a magnificent job running those. That's how he became the richest man in the world. And, I suspect the investment community can differentiate between things he is qualified to do and things he might not be qualified to do. Now, the jury, of course, is still out on Twitter. Maybe Twitter goes bankrupt. Maybe we're here in 2 years saying Twitter is more profitable than it's ever been. Who the heck knows?
Sure.
Right? But I suspect the investment community can differentiate between what he's doing at Tesla, what he's doing at SpaceX, and what he's doing at Twitter. Having said that, it is never good to fail publicly in a big way. That always hurts you somewhere. And it's never free. But, will that be incredibly damaging to his ability to, get resources for these other companies? I would tend to wonder about that. I think the investment community could easily see the difference and trust him to run Tesla, but not Twitter.
Sure. Jury's still out. I'm sure we could do this episode again next week and have a whole new conversation. And I think that about wraps us up. Mm-hmm. Yeah. Professor, we sincerely appreciate you taking the time to discuss all of this with us. It has been a great honor and a pleasure.
Well, it's been my pleasure, and I look forward to seeing what happens.
We do as well. Yeah. Thank you for joining us, and we look forward to having you again sometime in the future.
Outstanding. I wish you guys the best of luck.
Thanks, sir. Bye.
Thanks for listening. Emphasis Added is a podcast by the Houston Law Review. If you like what you saw, check us out on YouTube or your favorite podcast app.
Follow us on Instagram at EmphasisAddedPod, and check out the Law Review at HoustonLawReview.org.